the matter of Amy Skuse versus Pfizer. May we please have appearances of counsel?
Good morning. My name is David Kott. I'm a lawyer with McCarter & English, and I represent three amici curiae: the New Jersey Business and Industry Association, the New Jersey Chamber of Commerce, and the Commerce and Industry Association of New Jersey, which are the three largest business trade associations in New Jersey. I want to make four rapid-fire points. First, the Federal Arbitration Act preempts contrary state law, and it preempts both contrary state statutes and contrary decisions of state courts. Second, under the Federal Arbitration Act, arbitration contracts must be on, quote, equal footing, close quote, with any and all other contracts. You can't discriminate against arbitration contracts. Third, the appellate division decision in this case, in deciding whether an arbitration contract was formed, held that for an arbitration contract to be formed, a specific word needed to be used. That word was agree. And that may or may not be part of Leodori, but that's what the appellate division held. The appellate division also held that as a matter of law, there could never be an arbitration contract formed by virtue of performance. And the last thing the appellate division held, and I'm not faulting them because this may be found in Leodori and Annalise, is that rather than applying a preponderance of the evidence standard, which we would normally do in a civil lawsuit, the standard to be applied was clear and unmistakable. That is, did the parties unambiguously agree to enter into an arbitration contract? Fourth, the appellate division decision, and some of the decisions of this court, do not put arbitration agreements on equal footing. If I go on the Brooks Brothers website and I'm looking for a 100% cotton button-down shirt.
Why is that not surprising?
And it's on, I can buy it there for $140. And there's a box I can click on, and the box says order. And I click on that box. Brooks Brothers sends it to me, and now I wear it. Brooks Brothers and I have a contract. We have a contract because I clicked on the word order, that is, the word created the contract, and by virtue of my conduct, receiving the shirt and wearing it.
What if the click box said acknowledge? Are you going to get that shirt?
Absolutely.
Get a T-shirt that says acknowledge.
and Mr. Chief Justice, I will tell you, I thought about wearing French cuffs today because I know that Your Honor wears French cuffs. And in all candor, if I thought that would help me, I would have done it.
I think...
Maybe not this one.
I don't know that.
Maybe not this Chief.
Let me...
Exhibit A.
Wrong court.
I can't acknowledge that.
Wrong court. So let me in conclusion tell you what I think the proper legal analysis.
What's point 4? I don't understand point 4.
Point 4 is that the appellate division did not put arbitration contracts on equal footing.
And you kind of suggest that Annalise is in that group. Is that what you're saying?
Well, Annalise is, in my view, a little different issue because Annalise didn't deal with contract formation, in my view. I'm happy to argue about Annalise again, but I'm not sure some of that's really in this case.
Let me ask you about best practices, because obviously you advise clients, and the world today, in companies all over the place, large and small, is uniform communication of policies and procedures and training you have to go through and how to use Word, point whatever, and et cetera, cybersecurity, phishing emails, everything is on these training modules. Would you agree that while it may be cost-effective and efficient to put an arbitration agreement on a training module. Would you agree that there are better ways to communicate an arbitration agreement to employees than putting it in that setting?
I'm not sure I would, and I'm not sure they're realistic ways. I mean, we have an employer here, very large employer, with, Mr. Lindhorst said 27,000 employees. I will accept that as true. It becomes cumbersome and nearly impossible to deal with hard paper on 27,000
Not talking about paper. I'm talking about if email is used, treating an arbitration agreement and what is going to become the basic terms of employment a little bit differently than the training module that tells you that your social media should be X, Y, and Z.
I think an employer could do that, but I don't think that's legally necessary. You're going to put a lot on the training module that may be legal in nature.
Is it really that much? I wonder if you think we would be here if the click box said, click here to acknowledge that you received and agree.
Well, I don't think we'd be here because I don't think the plaintiff would be taking an appeal. But I think when you walk through the door into the courtroom, the justices, I don't think you check your common sense at the door. And to me, when you read the words of that slide 3, and the employee says, I acknowledge that if I continue to work for 60 days, that I'm bound by the arbitration policy. I don't think you need to have the word agree unless you're going to have special rules for arbitration, unless you're going to say we're really concerned about arbitration because we have a concern about the process, and therefore we're going to have a special rule that requires the word agree. I think and in one of the briefs, I think it was Pfizer's briefs, they quoted one of the legal dictionaries that said acknowledge and agree are the same. But just as a matter of common sense, if I'm an employee and I say, I read a slide that says, if I stay employed for 60 days, I've agreed to arbitrate, and I say, I acknowledge this. If I'm the judge, as the law division judge here did, I say that's an agreement. We don't...
Well, I'm not sure Leodori says anything other than that. If you look carefully at the language on page 307, Leodori talks about not needing to repeat all the language of an arbitration agreement, and that an acknowledgement of the agreement, if the agreement itself says the employee and employer agree to something, the acknowledgement is enough. And yet we're now talking as if the click has to use the word agree because that's what Leodori said. I don't read Leodori as saying that specifically. And in 2 sentences, Justice Venero was pretty clear in saying you don't have to repeat all that language in your actual employee response.
I accept that reading, Justice Levecki, of Leodori, but clearly the appellate division here, it's clear as a bell, said the word agree had to be used.
I agree. Do you agree, do you believe then that the appellate division in this decision took Leodori and expanded it?
I do, and I think they expanded it, that they're in a way coming to a question Justice Patterson asked to Mr. Lindhorst, well, are we talking about all contracts? All contracts. That's why I used the Brooks Brothers. All contracts. Or I agree to sell my used car to my next-door neighbor. Mm-hmm. We don't require the word agree.
This language says in 2 places on 2 different screens that the employee and Pfizer agree to individual arbitration as the exclusive means of resolving disputes. I mean, I see it on one page, I see it on another. And, when I look at that and I look at the language on page 307 of Leodori, which says the acknowledgement form need not recite that policy verbatim, as long as the form refers specifically to arbitration in the manner indicating an employee's assent. The acknowledgement, they've already said, can indicate assent.
And that's the genesis of my comment about when you walk through the door to come to the courtroom, you don't check your common sense. When you read all of these slides together, and this is not my issue, but I looked at it afresh the way the court would. Mm-hmm. When you read all these slides together, under any common sense reading, this employee agreed to arbitrate. So finally, Mr. Chief Justice, I think the proper legal analysis here is on contract formation. to use generally accepted contract formation principles. What I said in earlier arguments to both Justice Levesque and Justice Patterson, usual rules, back to basics, based upon the words used and or based on the conduct of the parties, by a preponderance of the evidence.
Are you suggesting that the language is less than clear and unmistakable in these manuals?
I don't think it's less than clear and unmistakable, but the appellate division did, and if that's the standard they applied, it's preempted by the Federal Arbitration Act.
I'm trying to understand what your argument is, because of your argument is, as your co-counsel, that it's clear and unmistakable, then we wouldn't be reaching the other issue.
I think that's a fair statement.
Does the appellate division's decision, by essentially saying acknowledge is not a word that can express assent for purposes of at least an arbitration contract, is that calling into question the validity of other categories of contracts that might use that word?
Well, it is, and that's part of the reason why I use the Brooks Brother example. I think we'd all, as lawyers and as judges, agree when I click order, I've made a contract. So there are a variety of words that can be used to make a contract, in addition to conduct, Justice Patterson.
The word agree is not essential.
I don't believe, as a matter of our common law, agree is needed. But if somebody is saying that, I believe it's preempted by Section 2 of the Federal Arbitration Act.
Thank you, Mr. Kott.
Thank you.
And thank you to all counsel for the very helpful arguments. We'll take the matter under advisement.